I think the legislative bill drafting manual should be published here in California. Most are not aware, but according to the National Conference of State Legislatures, NCSL, about half the states publish the manual used by their state's legislative drafting attorneys. California, in the Office of Legislative Counsel, is one of those states that does not. So, why do I think our state should publish its drafting manual? I think it would help enhance the ability of the state's judiciary to better interpret statutes. When first reviewing a statute, judges and justices rely upon the plain meaning of the words in the statute. However, when that statute is ambiguous, then our state courts will try to ascertain the intent of the legislature. And in my mind, one helpful document to assist the judicial branch in interpreting a statute could be the California Drafting Manual used by the attorneys in the Office of Legislative Counsel. So, why is that? Well, this has a lot of ministerial and behind the scenes material, I'm certain, but the manual also sets forth the rules that the California legislature's attorneys follow when they draft bills and amendments that ultimately become statutes in the state's 29 codes. Knowing how and why these statutes are drafted in their manner, in my opinion, could benefit the judges who are trying to understand and interpret these statutes crafted by the legislature's attorneys. Now, while allowing judges access to the drafting manual certainly will not answer all questions by any means, there are undoubtedly some valuable insights that can be gleaned by an examination of the manual's directives and the basis for those drafting directives. So while judges certainly desire to rely primarily on the textual language of a statute naturally, having some insights into drafting practices, I think, will give the judicial branch a better understanding of the legislative perspective. I've often said in speeches and in writing that I think legislators and their staff should get firsthand experience in statutory interpretation training from the judicial branch. And I also think judges should get firsthand experience in the legislative process and legislative drafting training from the legislative branch of government. This would give both judges and legislators a better perspective on each other's roles. Now, while the courts certainly wouldn't have to be mandated to follow the drafting manual, when interpreting an ambiguous statute, they don't even have to follow codified statutory construction principles. But they could at least consult with with the bill drafting manual, and I think that would be valuable and some helpful insights into why certain language is used or not used in California bill drafting. More importantly, from my perspective, if the stated goal of interpreting an ambiguous statute is to try and ascertain what is the intent of the legislature with this statutory language, then again, I think the drafting manual could shed some light on that goal and assist judges and justices in this state in that crucial endeavor. Again, this is because the legislature's drafting attorneys have a method of drafting, and some of those drafting rules are unique to California and should be known by the judicial branch. I even think that the judicial branch could suggest, perhaps where appropriate in their published decisions, where perhaps changes in the drafting manual are warranted, or maybe they could suggest some additions to the drafting manual where it may be silent. In other words, having access to the manual, I think, could actually help both the legislative and judicial branches of state government. California continues to be less of a common law state and more of a statutory state. And as such, I really think the judicial branch should be assisted in its interpretation of state statutes that are obviously drafted by the legislative branch of our state government.